Rich.
No, Your Honor.
Mr. Kukuski, any proofs from the defense?
I would be calling Oliver Hill to the stand, Your Honor.
Okay, Mr. Hill, if you want to come over to the witness stand here. As you arrive, if you can, as best you can, raise your right hand for me. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can see it there. Go ahead.
State your name for the record, please.
Oliver Winston Hill, the third.
And Mr. Hill, we're here today regarding an alleged bond violation that occurred here in April on the 16th or the 14th through the 16th. Are you familiar with that
I am.
and the violation that's been alleged?
Yes, I am.
How long have you been wearing that ankle monitor, that tether?
Since January 31st.
Okay. And do you recall that device having to be serviced by Ms. Fenlon at any time during the time you've been wearing it?
Yes, I do.
When was that and what was the services?
It was just about 2 days before the storm that we had. She contacted me, came to my home.
This isn't just a routine bond violation hearing. This is a courtroom clash between technology, accountability, and reasonable doubt. A defendant wearing an alcohol monitoring tether, a suspicious tamper event, and a court forced to decide, was this a technical malfunction or a deliberate attempt to cheat the system? As testimony unfolds, we'll see conflicting narratives, scientific uncertainty, and a judge who must separate possibility from proof. But here's the real question. When technology says one thing and behavior suggests another, who do you believe?
Took it off my ankle, and I believe that she changed the battery in it because she assumed that we were going to lose power.
Okay. Were there any other times?
No, that was it.
Okay. Did you not in fact see her due to a problem when you arrived in the county jail?
Yes, I did.
And what was that for?
It was a little bit loose on my ankle,
Okay.
and then there was a screw loose on it.
Okay. And Ms. Fenley came in and serviced that for you?
Yes, she did.
And when was that?
It was Sunday.
Okay. Now, during this time, you've been wearing that alcohol tether and you've been on the monitor there. You've also been doing urine screens. Is that correct?
Yes.
How often are you doing those?
In the beginning, it was twice a week. And then 1 week, I went like 3 days in a row. And the following week, 2 days in a row. So it was basically 5 days in a row. So I called up to the court. I said, something doesn't seem right. You know, it's a lot of days in a row. So they reset it. And then after that date, it was once a week after that.
Okay. And did you in fact test and produce a urine screen on the 15th of April?
Yes, I did.
And did you get the results of that test and provide them to the court?
Yes, I did.
And I'm going to show you what's been marked as defense's proposed exhibit A. Do you recognize that exhibit?
Yes, I do.
And how do you recognize it?
I've seen it before.
Is this the test that you got from them?
Yes.
Regarding the test that you took on the 15th?
Yes, it is.
Your Honor, I move for the admission of defendant's exhibit A.
Any objection?
Your Honor, I haven't seen it.
Okay, you want to show it to them?
No objection.
All right, exhibit A is admitted.
And the results of that test, can you tell me what they were, Mr. Hill?
They were negative.
Okay. And on the 15th, did you come to the courthouse, as a matter of fact?
Yes, I did. Right after I did the urinalysis.
What were you here for?
I came here to turn in my SoberLink device.
What'd you see?
I took it. I first called Megan Fenlon, and she told me to bring it here and to give it to Emily Wergu.
Okay.
So I turned it in, and then I came upstairs and I went to the circuit court to inquire about a sobriety court, and then on the way downstairs, I seen Your Honor coming up as I was the last flight of stairs.
Okay, do you recall what time that was and when?
It was probably about 1:30-ish, approximately.
And if that test that you took on the 15th indicates that you took that test at about 11 o'clock, maybe quarter to 11.
Okay,
Did that verify your timeline better?
yes,
So you would have came to court after taking that test, so maybe closer to noon or 12:30?
correct. I'm
Okay.
sorry.
And so you're here in that building, how long were you here?
Not too long, probably about 10 minutes,
Okay.
possibly a couple more.
Have you had any other, since the time you've been placed on the alcohol tether and you've been urine screening through there, has there been any other violations or any other incidents?
No, there had not.
Now, you had Miss Fenlon come in and service your device because of a loose screw and a broken plate, did you say?
Your Honor, it's already been asked and answered.
Just
Sustained. I promise I'm paying attention.
promise you're paying attention. Okay. Do you know how your device and the screw got loose on that device?
I have no idea, no.
Did you have any indication from Ms. Fenlon on how that might have occurred?
I'd object as to hearsay.
Sustained.
Those are all the questions I have, Your Honor.
Can you cross?
No, Your Honor.
You can step down, Mr. Vince. Any further proofs, Mr.
The
Perkins?
defense would rest at this time, Your Honor.
Any rebuttal proofs, Mr. Vince?
No, Your Honor.
Argument, Mr. Pitch?
Your Honor, I would ask the court, based on the testimony of Lainey Fryer, to find that there was alcohol detected, even though it wasn't a confirmed event. It sounds like even the defendant can interfere with that being a confirmed event. And therefore, the tampering was a violation. Mr. Hill had been incarcerated due to sober link and violations. He was released and then returned to jail after this tether tampering, which had detected alcohol. As far as his testimony as to the battery being changed, or he said on Sunday, so May 4th, the nail or screw being tightened, I don't think that would interfere at all based on Ms. Fryer's testimony with the science behind the tampering. Thank you.
Thank you, Mr. Perkins.
Your Honor, we're here today for a bond violation in which my client has been alleged to have tampered and had a confirmed alcohol detection with his device. And the burden of proof is on the people, and that burden would be beyond a reasonable doubt. At this time, the only testimony that we have from Ms. Fryer is that, well, there's deviations in this machine. It's about 99% accurate. I would question whether those devices and the admissibility of those devices, even in court, to meet that burden of proof. Again, my client has readily admitted any violations that he's had in the past. He's come to court, he's fallen on the sword, he's taken his lumps. He would, and I wholeheartedly believe would admit to a violation if he had one here today. But that's not the case. He's admitted maybe 3 violations in the past just on this file alone. He's had this device on his ankle since the 31st of January. Almost 3 months go by before there's any problem, any issue. He's done 17 drug urine screens in the meantime with no problem, no issue, no problem with this device. He's come to court on the 15th. If he's tampering with this device, sticking something in there to mess with the infrared sensor so he could drink alcohol, why the heck would he come to court in the county building on that day? And why the heck would he go drug test and drop urine on the 15th in the middle of this alleged violation and this alleged tamper event? Oliver Hill's a bright guy, but he's not that dumb to do that, Your Honor. And there's just not enough evidence or testimony that has been placed on this record today that would indicate to me, or should indicate to the court, that there has been a violation and that a violation has occurred. Mr. Hill has complied with this order. He's adamant he hasn't tested. He's testified today that Ms. Fenlon had to service that machine. A screw was loose on that machine upon entering the jail. Again, 83 days on that device, on that machine. And it wasn't until the 80th or just less than that day that he's alleged to have been tampered from this report. The report ends on the 23rd. So a significant period of time has lapsed. If there was a relapse or there was alcohol use, it would have occurred sooner, Your Honor. We'd ask the court to find that there has not been a violation of this matter. The prosecution has not met their burden of proof, Your Honor. Thank you.
Thank you, Ms. Goodrich. Any rebuttal argument?
No, Your Honor.
All right, well, I'm going to find Mr. Hill in contempt of court for tampering with the alcohol tether. There is some question about whether alcohol was consumed or not. The alcohol detection on from the skin can't be confirmed that it was an event of consuming alcohol for the reason that, or it could be for any number of reasons, and one of them could be the device being tampered with, which that interferes with its ability to detect alcohol. That seems, I'm not surprised by that. That seems rather common sense. One mitigating fact there is on the 15th, right in the middle of the detection, right of the tamper window, there is a negative alcohol urine test collected on the morning of April 15th. The tamper with alcohol being detected continued past that date till the early morning hours of April 16th. But it's not really clear whether there was any alcohol being consumed or not by Mr. Hill. But what is clear is that there was something being done to interfere with that device's proper operation, which is designed to test for the presence of alcohol. So I think there certainly is proof beyond a reasonable doubt that Mr. Hill is in contempt of court for tampering with the device. So he's found in contempt. As to sanction, Mr. Kukuski, any allegation?
Your Honor, again, Mr. Hill, throughout this case, has readily admitted any problems or any violations that he's had with alcohol and alcohol use. He was incarcerated for 50 some days with a prior violation, and he's very adamant that this time he's not using or consuming alcohol, and it can't be, that fact can't be proven here today and was not proven here today. I would ask that the court allow him to be back out on bond on his device. He's got a lot of cleanup to do and work to get done. As I indicated the last time that we were here, the court was so gracious to put him on the ankle monitor, and he was very grateful. We are very grateful. We stand here very thankful to the court to allow us that opportunity. He went 3 months before this alleged tamper device, and I don't know how that happened, how the screw came loose. The plate had gotten cracked and Ms. Fenton had fixed it. But regardless, there was an issue with that device. It has been serviced, it has been fixed. And so given that and the time that he set now on this violation, waiting for his hearing, I'd ask the court to just sanction him to that time served, allow him back on bond so that he can provide for his family, take care of his mother, and do the things he needs to do to get his home clean since this whole event has happened in the ice storm. So thank you, Your Honor.
All right, thank you. Mr. Hill, you don't have to say anything, but before you decide on your sentence for the contempt, you are allowed to tell me anything. Is there anything you want to tell me about that or no?
Your Honor, I didn't do anything to this. I didn't tamper with it. I did the drug test. I had no idea that there was it wasn't a sock. There was nothing in between my ankle and that device.
Right, thank you.
That's all.
Thank you. Ms. Goodrich?
Your Honor, Mr. Hill, as mentioned, had violated on his sober link, which sounds like he had admitted to. Now he's violated with his tether. I believe he is a risk of public safety, and 93 days should be ordered with his bond continued to be revoked. It looks like the incident date of this underlying case is July 2nd of 2024, so it may be time for trial to be set.
Thank you. Well, I don't know whether Mr. Hill is guilty of the drunk driving that he's charged with or not. He has the right to trial about that, and we need to be scheduling one here. But when he's got 5 prior drunk driving convictions and at least 4 or 5 prior felony convictions on top of those, and a revoked license, and it's alleged that he's out with all that history driving drunk on that revoked license. So there's conditions placed on his bond so that we can be assured that Mr. Hill isn't placing the community at any risk of harm. He violated those bond conditions by using or drinking or both, and I revoked his bond. And then he sat 56 days on a revocation of his bond. And then, I think a lot of local attorneys can tell you, I don't give second chances when there's a violation of bond in that nature in a drunk driving case. I'm not entirely sure why I did for Mr. Hill, but that is not the norm for me to then cut you back loose in the community. But I did, but with a tether. So now I know I want continuous monitoring of your skin so that I can know that by me putting you back out, despite that prior violation, that I'm not endangering the public by putting you back out there among them. And, we've got evidence that I found that you tampered with that device. So that's just makes me regret reinstating bond in the first place, to be honest. So the sentence for that second contempt, the first one was 56 days. The second contempt is certainly not going to be less than that. So this will be a 93 days in jail, credit for 14 days previously served. Bond will continue to be revoked. So even at the conclusion of the contempt sentence, you can't be released again until I decide to reinstate the bond. All right, so Mr. Krupkeski, that takes care of the contempt issue. As to the underlying case, where are we at in terms of docket call?
Well, Your Honor, I did receive a recent emailed offer from the prosecutor that I, in fact, was just discussing with my client to see whether that was something that he'd be amenable to. Your Honor wants to set this matter for trial in 3 months, then maybe an interim docket call so that we could discuss that.
Well, maybe I'd like to set it for trial if we're going to try it. I don't want to set it for trial if we're going to resolve it. So maybe I can have us come back next week, or you're not here you're not available on the 13th, is that, or are you available?
I don't believe I am available. I don't have my phone with me, Your Honor.
The only thing I've got you on is for Smiley for arraignment or plea taking. Oh, and Wheeler.
Smiley and, I'm sorry.
Wheeler.
Okay.
So I mean, I could add this to next week's docket.
Let's do that.
And then you can review the offer with your client. And if it's resolved, we can go that way. If not, we'll set it for a trial.
That sounds good, Your Honor. Thank you.
Okay, so let's add it on for next week at 1:40.
Thank you, Your Honor.
Okay, anything further from the people?
No, Your Honor. Thank you.
Anything further from the defense?
Nothing at this time, Your Honor. Thank you.
Okay, Mr. Hill, we'll see you next week. All right, good morning. We're back on the record in the 53rd Circuit Court. And up next, we have People v. Elmer Truman. It's 2 file numbers, 25-6978FC and 25-7035FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
Good morning, may it please this honorable court, Kareem Johnson, for behalf of Mr. Truman, who's seated to my immediate right.
All right, good morning, Mr. Truman. I've been handed a plea agreement form and some joint exhibits establishing the factual basis and some amended informations to facilitate that plea. Is that how we're proceeding, Mr. Johnson, today?
Yes, Your Honor.
All right, Mr. Truman, would you please stand and as best you can, raise your right hand for me? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Okay, you can be seated. Are you Elmer Lewis Truman?
yes, I am.
Okay, Mr. Truman, I'm sorry, first, Mr. Johnson, the reason for a no contest plea would be,
Civil liability.
And Ms. Goodrich, do the people consent to the tendering and acceptance of such a plea in both files?
Yes.
All right, Mr. Truman, in a no contest plea, I won't ask you about what happened. Instead, I'll review some exhibits that the parties have marked to establish a factual basis for what happened. But I am going to ask you a lot of questions just to make sure you understand what's going on and that I understand the rights that you're waiving. So at any time, if you have a question, go ahead and ask me. If you need more time to talk to Mr. Johnson, you just let me know. Does that sound all right?
Yeah.
All right. Now, my first question to you, Mr. Truman, is do you understand that a no contest plea has the same legal effect as a guilty plea in the criminal side of things, meaning that you would be convicted of those offenses and I would have the jurisdiction or authority to sentence or punish you for them? Do you understand that?
Yes.
So I have to advise you the maximum penalty that you could face for the charges you'd be offering to plead to. In file 69, I'm sorry, Mr. Johnson, do you consent to the filing of the amended informations in both files?
Yes, Your Honor, we waive formal reading and stand mute for purposes of arraignment.
Okay, thank you. Mr. Truman, in 6978, you'd be offering to plead no contest to count 6, criminal sexual conduct 3rd degree as a habitual offender 3rd. That would be a felony punishable by a maximum of 30 years in prison with mandatory AIDS and STD testing. And it's also a tier 3 or lifetime offense registry under the Sex Offender Registration Act. And added count 12, criminal sexual conduct in the 3rd degree or 2nd degree, person under 13, defendant 17 years of age or older as a habitual 3rd. That would be a felony punishable by a maximum of 30 years in prison, mandatory AIDS and STD testing. Again, a tier 3 offense under the Registration Act. And it also would subject you to lifetime electronic monitoring upon parole from prison. Do you understand the maximum penalties you could face in that file?
Yes.
And in file 7035, conspiracy to commit obstruction of justice with the habitual offender 3rd would be a felony punishable by a maximum of 10 years in prison and a $10,000 fine. Do you understand that maximum penalty?
Yes.
And although it looks like this would be consecutive sentencing because 7035 was committed in the jail. Is that right, Ms. Goodrich?
Yes.
Okay. So technically that'd be consecutive sentencing, which would be 30 years plus the 10. So maximum possible penalty of 40 years. Do you understand that?
Yes.
All right. All right, Mr. Truman, do you understand if you enter this no contest plea, you won't have a trial and you'll be giving up the rights that you would have had at trial?
Yes.
I want to remind you of the most important of those rights. You'd have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proves your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense and have me order them to show up. You would have the right to testify in your own defense or to remain silent and not have your silence used against you. Do you understand those rights?
Yes.
Do you have any questions for me or for Mr. Johnson about any of those rights?
No.
Do you wish to give up those rights and enter a plea today?
Yes.
If I accept your plea, you'd be giving up any claim that it was caused by promises outside the plea agreement or by any threats or other inducements for the plea. Do you understand that?
Yes.
And when you enter a no contest plea, you lose the right to appeal. If you wanted to appeal, you'd have to seek permission by filing an application. And the types of issues that you could raise on that appeal are very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes.
All right, the plea agreement provides in exchange for your no contest plea to those charges, the prosecutor will dismiss the remaining charges, the habitual 4th, and there is a sentence agreement in 7035 only, credit for time served with no additional incarceration. Do you understand the terms of that plea agreement?
Yes.
That sentence agreement is not binding on me. If I didn't want to follow it, I wouldn't have to. But if I didn't follow it, you'd be allowed to withdraw your plea. Do you understand that?
Yes.
That's unless you engage in some misconduct between now and your sentencing, in which case, by your misconduct, you'd be losing the right to withdraw the plea even if I didn't follow the sentence agreement. Do you understand that?
Yes.
Other than the plea agreement, has anybody promised you anything to get you to plead no contest?
No.
Has anybody threatened you to make you plead?
No.
Is entering that plea your own free choice?
Yes, it is.
Knowing all this, in file 6978, how do you wish to plead to the charge in count 6? Criminal sexual conduct in the 3rd degree as habitual offender 3rd. Guilty, not guilty, or no contest?
No contest.
And how do you wish to plead to the charge in count 12? Criminal sexual conduct in the 2nd degree, person under 13, defendant 17 years of age or older, habitual 3rd.
No contest.
Okay, I have reviewed what's been marked as joint exhibit number 1 in that file. I believe it does establish a factual basis with just a couple questions that I'd ask. Back in January of 2018, were you older than 17 years of age?
Yes.
And was the victim in the matter under the age of 13?
Yes.
And at that time, did you have a prior conviction for criminal sexual conduct in the 4th degree in 2002 out of Emmett Circuit Court?
Yes.
And in 2014, a conviction for a welfare fraud in the 53rd Circuit Court?
Yes.
All right. In file 7035, how do you wish to plead to the charge of conspiracy to commit obstruction of justice, habitual 3rd?
No contest.
All right, and I have reviewed what's been marked as joint exhibit 1 in that file. And I do find that it establishes a factual basis, and the answers that you gave previously about your prior record established the factual basis for the habitual. Mr. Johnson, are you satisfied that a factual basis has been established?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Mr. Johnson, are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe in your judgment that the court has fully complied with the requirements of MCR 6.302?
Yes, Your Honor.
Ms. Goodrich, do you agree on both those matters?
Yes.
All right, Mr. Truman, I find that your no contest pleas are entered knowingly, voluntarily, and understandingly, and that there is a sufficient basis, both in fact and in law, to believe that you are guilty of those offenses. So I do hereby accept your no contest pleas to them. We'll schedule sentencing for when Mr. Johnson is here on another matter on August 26th at 2:40 in the afternoon. I'm going to direct you to cooperate with a pre-sentence interview so that the Department of Corrections can write a report for me with recommendations about what to do. I don't know what the bond situation is, but based on the plea entered, I'll go ahead and revoke his bond at this time, just to ensure that he's held without release pending the sentencing. Anything further from the defense?
Yes, Your Honor. I'd like to participate via telephone if possible in the PSI interview.
Yes, that's absolutely you and your client's right. If you just communicate that to the Department of Corrections, they'll accommodate that.
All right, thank you.
I mean, I don't know about the telephone or Zoom or in person, whatever. I can't direct them about that. They have their own policies about that, but they do have to allow your participation. Anything further from the people?
No, Your Honor.
All right, we'll see you then, Mr. Truman.
This case is a powerful example of how modern monitoring technology intersects with the legal system, and how even uncertainty doesn't always work in a defendant's favor. Despite a negative urine test and no definitive proof of alcohol consumption, the court ultimately found that tampering with the tether itself was proven beyond a reasonable doubt, and in the eyes of the law, that was enough. The result, a 93-day jail sentence, continued bond revocation, and a clear message from the bench. Compliance with court-ordered monitoring isn't optional, it's absolute. But what do you think? Was this a fair ruling based on the evidence presented, or did the uncertainty leave too much room for doubt? If you found this case as intense and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.